Welcome to CareSmart's 360 on Air, a home care podcast. I'm Mike Palladino, a senior account executive here at CareSmarts. Today, we're tackling a topic that's sending shockwaves through the home care industry. As of April 2024, the Federal Trade Commission has effectively banned non-compete agreements in various industries, including home care. That's right, the rules of the game have changed, and it's time for home care providers to adapt. For years, non-compete agreements have been a staple in employment contracts aimed at protecting businesses from competitors and preserving trade secrets, of course. But with this new regulation, the FTC is prioritizing worker mobility, competition, and of course, innovation. So what does that mean for home care providers? How will they need to adjust their strategies to comply with new rules, and what opportunities might arise from the shift? In this episode, we'll explore the significance of adapting to evolving non-compete regulations in home care. We'll discuss the implications of this ban, the benefits and challenges it presents, and what home care providers can do to stay ahead of the curve. So let's dive in and get started. Our expert guest today is Will Cantrell, a seasoned attorney and expert in competition, injury, and workplace disputes, and he'll join us to share the insights on the topics aforementioned before. With over 13 years of experience in private practice, Will has represented leading companies and individuals in high-stakes business disputes, including employee mobility and non-compete agreements. As a founding member of Cantrell Chouette, a law firm known for its world-class service and innovative fee structures, Will brings a wealth of knowledge and expertise to our conversation today. Welcome to the podcast, Will.
Hey, I appreciate it, Mike, and happy Friday to you. And I appreciate having me on board here. The timing is certainly ideal. I was speaking at in a different forum just last week to a number of home care executives throughout the nation in my home state of Florida. Let me rephrase that. My home state's Georgia, but I've been residing in Florida for quite a while now, and I practiced in Georgia and Florida.
Awesome.
But yeah, to a couple of things. First, my background, my practice is effectively employment law and business litigation, but within those very broad, kind of umbrella terms, over 50% of what we do all day, every day is providing guidance and litigation counsel to companies, executives, and workers relating to employee mobility issues. And that's, again, it's a fancy way of saying restrictive covenants, non-competes, non-solicits, NDAs, trade secrets, things of that nature. So effectively people in transition or the companies dealing with folks in transition or both coming into the company and leaving the home health care agency. Regarding the FTC ban, I'll certainly give a highlight of it, but to lead with what I think is probably the most important aspect of this is the question of whether it's going to become effective in the first place.
Yeah.
This is something that obviously made a big splash at the beginning of the year. The FTC actually first noted they were going to be issuing a rule early last year. They took their time, as they should have, rolling out the proposed rule. That was early this year with an effective date. As of right now, I believe it's September 1 or September 4th. Regardless, a court in Texas has already come out and indicated they will likely be issuing a national ban at some point in August. A different federal court came out just last week in Pennsylvania and said that this ban is just fine; it can proceed. So what happens in those situations? Well, first, what's likely going to happen? I can't guarantee any of this, but I'm certainly watching it closely. I expect the court in Texas to issue that national ban at some point in August. I expect this, and then at that point, either one or two things are going to happen. Either this will make its way up to the U.S. Supreme Court, where there's no guarantee, but most people who watch this closely, both this specific law as well, a proposed law, law to be, as well as the current trends in the U.S. Supreme Court, we'd expect the U.S. Supreme Court to strike this down as an overreach by the FTC, in which case you would be left with what you currently have, which is 50 states with 50 different slightly rules.
Yeah.
Some of them, one end of the pendulum, you've got California that bans all non-competes and non-solicits, with a very few exceptions, to the opposite end of the spectrum with states like my home state, Florida, which, they're all enforceable with as long as you meet certain requirements. Okay.
Yeah.
So the alternative that may happen is this not going to Supreme Court, and that would likely be in the scenario if Donald Trump were to take office. There is a high probability that he would replace the person who's currently in charge of the FTC. And the new person in charge of the FTC would certainly walk back the new rule. That'd be expected. So either way, there is I would say, a high probability that the current FTC non-compete rule that is scheduled to become effective in early September won't. Okay, no guarantee. And employers certainly should prepare as if it may.
Yeah.
But with that said, now jumping into the rule, and I'll get the quick Cliff Note version of it. In short, it bans all non-competes nationwide. And there's a rumor going around with a lot of employers that this does not apply to at least executives. That's a misnomer. You can't enter into new non-competes going forwards with executives if this rule were to become the law. And the exception only applies for a short period of time. I believe it's a year or two for agreements that you already have in place with certain executives. And these are only senior executives that are in policy-making positions and who make very high comp, effectively more than $151,000 per year. Okay, so certainly even with that temporary carve-out, it's still effectively going to gut 98% of the workforce non-competes that are out there. Okay, right. It would not apply now. The actual carve-outs would include franchisee and franchisors, and some of those do exist in this space, as well as in the context of buy-sell agreements. So if you're selling your home healthcare agency, whether to private equity or to another owner, in that case, the non-compete would still be effective, which it should be. I mean, why would you want to sell your business to someone who could turn around and compete? Apart from that, again, they're banned, period, for workforce. And it's not just employees, it's for all workers. It means all contract labor as well, interns, et cetera, anyone. To clarify, this would only apply to non-competes. It would not apply to or in any way impact non-solicit agreements or NDAs. So that's also very important.
Yeah.
As it stands, there's actually many home healthcare agencies who don't use non-competes, but they do use non-solicits and NDAs, in which case they're not going to be impacted at all.
Right. That's actually some good feedback, right? I think that the preamble you gave us really sets the stage for the podcast here today with the questions we're going to run through shortly. But I think it's important to delineate the differences between a non-compete, an NDA, and anything else that could really help protect an agency's operating structure and IP, right? But I think there's a lot to it, and as you mentioned, I think the most challenging part about this right now is there's just a lot of uncertainty as to what's going to happen. So it's how do you best prepare for that? How do you adjust and adapt to these things that either may or may not happen, depending on what happens in the fall as well? That's a big aspect of this too. So I'm excited to learn more, Will. I think this has been a great segue to jump into the first question, which what are the key implications of the FTC's ban on non-compete agreements in home care, and how do you think it'll impact the industry?
Well, a couple of things. First, I recommend the advice that I'm giving to my clients right now, which range from mom and pop startups to a handful of Fortune 100 companies is do nothing, wait and see. Obviously, you've probably already sent out some type of message to your workforce
Hmm.
acknowledging that this rule may come to fruition. But apart from that, wait and see. Now, how long should you wait and see? About 3 weeks. Okay. I'll give it about 3 more weeks. If there is not a national ban at that point, then you need to be reaching out to your non-compete or employment counsel because there is a required notice that has to go out to anyone who is impacted. And there's a form notice that the FTC provided along with the rule.
Hmm.
If, on the other hand, in the next 3 weeks, there is a ban that is ordered by likely that court in Texas that's nationwide, then there's nothing to do unless until that ban is lifted. So that's the short version of what employers need to be doing. Right now, just staying tuned to whether there's any changes in this being rolled out over the next 2 weeks. If there's not, then get those notices prepared, figure out who they need to go out to, and so those things can be disseminated come early September.
Yeah. Yeah, I think that's a good plan, right? I think it's hard to predict what may or may not happen, and if you adjust, contracts or other things that impact your business and how you operate, and then things don't end up coming to fruition, well, then you just done all this work for nothing. Maybe you had spent money redoing your contracts and legal fees or other fees, right? And I think that's a really solid piece of advice. Just kind of hold pat, prepare for it, understand what's coming, but also kind of, I think in this case, be a bit more reactive as to the nuance of what may or may not occur, right? So I think that's a good plan. And certainly if I was in the position of, a home care agency or in the space of running the business like that, I'd probably do the same thing, right? I think it's just kind of a holding pattern type status right now.
Yeah, yeah.
Which
Now,
I think, oh, sorry, go ahead.
well, I wanted to jump in, to answer more of your question is, what should employers be doing? And so
Yeah.
I'm going to get on my little soapbox for a moment here. I think non-competes are vastly overused, especially in this industry.
Hmm.
Okay. You look at why are non-competes needed in the first place, and really think the restrictive covenants, and by that it's an umbrella term for non-compete, non-solicit, NDAs, things of that nature, is to protect your legitimate business interests. Okay, what are those interests?
Hmm.
Let's drill down here. You've got customer relationships. That's number one. That's by far the number one reason. You've got employee relationships. You've invested training into them. Okay, and you've got confidential information. And of course, you've got your own trademarks and things of that nature. How else can you protect them other than a non-compete? Easy, a non-solicit, a well-written non-solicit, non-acceptance type provision, along with a strong NDA. That's going to take care of your customer relationships. That's going to take care of your confidential information. Non-solicits, can and should cover the workforce as well, and referral relationships, okay, and certain vendor relationships. So all of those things can be protected with things other than a non-compete. And so a lot of the home health care agencies will say, well, we want this for deterrent. They don't say this in public very often, but the private conversations is deterrence. We may
Yeah.
deter them from going to a competitor. Well, that's true, but it also has, it works both ways.
Yeah.
It also is a deterrence from having folks who otherwise would be working with you not wanting to work with you because of the non-competes. Top
Yeah.
talents, experienced talents, they're savvy enough to know what non-competes actually are, unlike a lot of people who are new to the workforce. So just realize there's pros and cons to
Yeah.
having non-competes. I think the best thing that a agency should do is have legal counsel. Don't go to Google. Don't just follow the lead from someone else's agreement you've seen. Have experienced legal counsel prepare a very thorough non-solicit and NDA. And there are a lot of unique provisions that you could include to really protect your agency. So it's, you think non-solicit, you can't contact somebody or a customer, okay, to solicit them. You can't contact an employee to have them leave. Well, you can go further than that. You can have a non-acceptance,
Yeah.
because usually the fight is the former employee saying, oh, I didn't solicit them. They came to me. I didn't solicit the referral source. They contacted me. And then we just had a conversation and they basically signed up with me doing nothing. that's their story. We know it's not true, but that's their story.
Yeah.
Well, the easy way to deal with that is just have a non-acceptance provision in the first place. Okay. You can go further. You can have provisions requiring inspection rights so that the home health care agency can require the former worker to, provide copies of the communications they've had with certain employees and customers post-employment. You can require the former employee to provide a copy of the agreement to their next employer or their next agency. Okay. Another important one that's often overlooked, you can require them to provide a long notice period that they're leaving, 30, 45 days. Well, what's the benefit of that? Obvious. It allows the agency to start, to the extent that they don't have anyone else there that has a strong relationship with some of these referral sources and customers, to start going in there and building those relationships prior to that person offboarding. So there's a lot of procedural and legal mechanisms at a agency's disposal that can really take care of all of their interests without having to rely just on a non-compete.
Yeah, I think that's beautifully put, and I think it also gives a bit of context to the question, and how will it impact the industry, right? And what are the key implications? So I think it's important information to be aware of. It's important to be prepared for it. It's also to understand the different elements that are going to affect you. But I think kind of circling back to your original point about it, it's also one of those things that right now maybe standing pat is the best course of action. But again, I think, as you've mentioned, it's important to recognize this kind of, these are the stipulations, or these are the things we've got to be aware of. From there, I think it's a great segue, based on what you were just describing, Will, in that, the next question I got for you is, how can home care providers adapt their employment contracts and policies to comply with new regulations, and what are the potential risks of non-compliance?
So first, let's unpack that. The last one is the risk of non-compliance. And I think you're implying what happens if the FTC non-compete ban goes forward, okay? Which is certainly not impossible. I think it's unlikely, but not impossible. If it does, then it's straightforward. One, there's fines involved. I don't know offhand what they are, but the FTC would certainly be looking to enforce this, and they would presumably be going after some of the larger agencies to send a message. As a more practical matter, the FTC is not going to have to be looking for violators. The workforce is going to come to them. The new FTC non-compete ban, the workforce in general in the home healthcare space is very aware of it. And so both companies and workers are looking at what's going to happen here. And so if this ban moves forward and an agency tries to enforce a non-compete, one, the worker is likely going to know that that's a problem. Okay, they're likely going to report that to the FTC and or the Department of Labor. And certainly if they go to an attorney, that attorney is going to know that's a problem. Okay. So, as far as non-compliance, the biggest things is just that everyone knows this is not allowed anymore. What are you doing having me sign this in the first place? And you're even crazier if you were to send me a cease and desist letter regarding a non-compete. Okay. It wouldn't exist anymore effectively after, I believe, September 1st or September 4th.
Right.
Going back to what policies can they put into place and what should be put in agreements, let me be clear. The following things I'm about to say should be done regardless of whether the FTC ban goes forward or not. Okay. The best practice is, one, have a well-written agreement. I touched on that briefly earlier. I'll get into it again. Okay. Have a well-written agreement that is standalone from a job offer document or a compensation agreement. And there's two benefits for that. One is the attorney, for reasons I won't go into, it makes it a lot easier for me to actually enforce it. Okay. Right. And two, it makes it a lot more clear and conspicuous to the employee what they're signing. You don't want to hide the ball. Okay. Have them sign it through DocuSign or something of that nature. That way you've got a copy and you don't lose what they sign. Because if you lose it, good luck enforcing it in almost all states. And just as important, the employee has a copy of it for their records. Okay. That's the onboarding part. On the offboarding part, make it standard procedure to send an offboarding letter to former employees. Okay. And it doesn't have to be, just a nasty gram reminding them of their post-employment obligations. It could be part of the more comprehensive offboarding letter that talks about any employee benefits and 401k and things of that nature. And then you throw in the blurb about reminding them of their obligations and include a copy of it. And that's
Right.
important because so many employees either A, didn't appreciate what they signed, or if they've been there for a long time, they flat forgot they signed something.
Yeah,
Okay. And they
definitely.
instantly go to a competitor. Okay.
Yeah.
Or reach out to former clients. So you don't want to hide the ball with it. Wave it around like a banner, both before when they're coming on board and when they're offboarding. Okay. The last part is what should go into it. Again, things of this nature, I view it as just as if you were going to sell your business, you certainly wouldn't draft up the documents themselves. You would go hire corporate counsel to take care of that merger or acquisition, as the case may be. Okay. Same thing here. These restrictive covenants, whether they are enforceable and to what scope, the language is everything.
Yeah.
Okay. Or certainly 80% of it. And the actual underlying facts is the rest. So go out and get yourself someone who specializes in this. Okay. Not a generalist. Go get someone who specializes in this. And it should include things like not only a non-solicit of customers and referral sources and vendors and employees and contractors, but also a non-acceptance of them. Okay. It should include things like requiring that individual disclose the agreement before they start work with someone new. Okay. It should include that having that employee sign an acknowledgement that they returned everything to the company, that they don't have any more confidential
Yeah.
information. So the list goes on.
Yeah.
Okay.
Could be exhaustive list for sure.
Yeah,
Yeah.
but the bottom line is if you've got yourself a 2 or 3 page document, that's not sufficient. When
No.
these things are done right, these are 8 to 15 pages long, and that's for your benefit.
Yeah.
Okay.
Yeah, absolutely. And, I imagine that there's a lot of agencies out there that have not given this much thought or don't really have those really protective agreements to really combat this kind of thing, right? And I think that's why I'm happy we're doing this podcast today, because again, these are really for educational and no promotional purposes in that regard. And it's just really helping everyone, what we like to say as level up, right? Understand how they can best protect themselves to adapt to changing rules, regulations, compliances, and just in general from competition and from other things out there, right? There's a lot of a lot of nuance in this, and it's important that people are aware of what they should be doing and how to manage it.
Well, I'll give you a perfect example of in this industry for home health care.
Hmm.
I would say almost half the time when I have a worker I'm representing, okay, and usually they're in sales, right? It's a marketing type person, and they get a nasty gram, okay, what I call a cease and desist letter. And I get that agreement and I look at it, and the home health care agency is accusing them of going after not only customers, but after the certain referral sources. Okay.
Hmm.
Some of these physician clinics and other
Yeah.
healthcare professionals who are referring out clients. Okay. Or for going after prospective customers. Okay. Prospective patients. And we will look at the actual agreement, and the only thing it prohibits half the time is soliciting patients. That's it.
Yeah.
That doesn't cover the referral sources. That doesn't cover any prospects. So if they're in sales, the door is wide open for them to go after anyone who wasn't actually a client yet.
Yeah.
Okay?
Absolutely.
And those are things those are easy things to button up.
Yeah, I think it's fair, right? Because if it's so broad in that regard, especially as you mentioned, like business development or in sales, the reality is if I have those relationships, that's what's enticing for me or as an employer for the next hire that I make or that I'm brought on for. That's part of my portfolio, right? So if I'm not restricted or if it's not very, black and white in terms of what I can or can't do, of course I'm going to leverage my network. That's part of probably why I was brought on somewhere else because of my expertise and my relationships and that kind of thing. So it's important that if you're offboarding somebody, especially on the biz dev side of home care, you protect yourself as an agency. Maybe they are required to transfer those contacts or uh, refute ownership of those contacts too, or something to that regard. But it's tough, and some people that are savvy that read that maybe they don't even join in the first place if that's part of the requirements, right?
Yeah.
So
And I was going to add, I know this is primarily for home healthcare agencies, but to the workers who are listening, don't be afraid to negotiate. So much the workforce thinks these things are boilerplate and they're non-negotiable, and that's just more often than not, that's not the case.
Yeah.
The reality is, if an agency wants to hire you, it's because they want you on board.
Yeah.
They're sold on you, and so
Mhm.
recognize the really the only time you're going to have real leverage in negotiating the details of these agreements is before you sign. So take
Yeah.
advantage of that.
Yeah, absolutely. 100% couldn't have said it better myself. It's something that it's kind of unrelated, but my sister is actually a very senior leader in HR. So she's involved in, curating contracts. It's in a different industry altogether. But when it comes to reviewing your employment agreement, reviewing your contracts, things like that, she's very well versed because she's worked with lawyers and legal teams to really curate these agreements that protect their line of business, right? And it's given me the opportunity to understand these things because I have somebody directly involved in my life that can educate me on it. But I think that's a challenge for most because a lot of the times you don't know what you don't know. And you don't know these things if you don't think about them or haven't experienced them. Sometimes you go through it and then you learn and you kind of got the butt end the first time so you don't do it again. But it's all really trying to help people level up their knowledge of why this is such an important thing in all walks of life and in all business practices and business industries. But I think as it relates to home care, we're in a very unique niche where people transfer agencies or leave agencies to go to other agencies all the time, right? Especially as a caregiver. Oftentimes what I see is caregivers are contract workers, they're 1099s, they work with multiple agencies at once. I see that being a huge risk if I'm running a business, right? You may have, maybe they might confuse client information or they access one system that one agency uses and another agency uses another system. Maybe those agencies use the same system, they're confusing their data. Like there's a lot of different nuance in there. And I think that's why this conversation is also exceptionally important in our space because there's just so much sensitive data out there. And agencies, to avoid fines and other things, have to make sure that data and the people that manage the data are protected, right?
Absolutely.
Amazing. Well, hey, that's a great segue into, we already kind of alluded to this, but number three question I have for you is what strategies can home care providers use to protect their business interests and trade secrets in the absence rather of non-compete agreements? And are there any alternative legal mechanisms they can employ?
Yeah, and we effectively already covered that one. In short, and it's worth beating that horse here. You've got to have strong non-solicits, period.
Yeah.
And as a practical matter, as someone who goes before judges on a very regular basis to litigate non-competes and non-solicits, you will get a lot of judges who very closely scrutinize a non-compete, even if you have one. So stop right there. If anyone has a non-compete and they think that it is enforceable merely because somebody signed it, don't drink your own Kool-Aid. That's absolutely almost never the case. Okay? A lot of judges scrutinize these and have a lot of sympathies for workers with respect to non-competes nationwide. Okay, it's not just a matter of which part of the country you're in.
Yeah.
And nor is it a conservative versus liberal thing. I think most judges scrutinize them and have sympathy for the workers in these situations.
Yeah.
On the other hand, non-solicits, that is where judges have very little sympathy for the workers. And the idea being that, not only did you sign an agreement that says you can't solicit, customers, again, you have to have a relationship with them, a substantial relationship. They can't just be any customers under most state laws. Okay. But the judge is aware, and then certainly the employer is aware, the home health care agency, that you've been paying these people to build these relationships with the referral sources. Okay. So I know a lot of workers who are marketing and sales, and they think these are my clients. I built these relationships.
Yeah.
No, you got paid to build these relationships
Exactly.
on behalf of somebody else. Now, if you brought them along with you, okay, that could be a different story. I still recommend you negotiate and carve those people out on the front end and not litigate it on the back end.
Yeah.
Okay. But that's going to be the biggest thing. And then, of course, some of those offboarding things and onboarding things we talked about. previously. But listen, the best way to avoid disputes over non-competes, either don't have them, which I emphasize they're overused. You'll be just fine without a non-compete.
Yeah.
Or if you're going to have them, make them narrow and be very selective on enforcement. It needs to be a pretty egregious situation, because what I think a lot of agencies who haven't litigated these issues don't fully appreciate is very expensive to go enforce a non-compete. And litigation in general is very expensive. So if you're a small agency owner, even a medium-sized one, they get sticker shock often when they hear what it's going to take to go enforce a non-compete. So that's all the more reason. If you're going to have them, make them narrow, only spend the money on the egregious situations.
Yeah. Yeah, it makes perfect sense. And I think, one of the things I've really taken away from this, Will, is the overuse of non-competes, right? I think we think, and there's many out there that would know this much better than I would, but we think we're doing this as a means of protecting us. But I bet you've seen this where it gets down to the nitty-gritty, and there's agencies or businesses out there that are spending so much money to review or to even protect from litigation against these NDAs, when it might have just been an easier breakup if they just didn't have one in the first place, right? And I'm sure it's much more complex than I'm kind of simplifying it, but I think there's merit to that, right? I think, it's warranted and definitely in certain situations, but I think that you have to understand why we're putting these things in place so that we can really act on them if it comes to it.
Yeah, absolutely. And I think one of the disconnects is that too many people view non-competes as any other type of contract.
Yeah.
In which case, hey, it's clear on its terms, you both consented to it, therefore it's enforceable. That's not how it works in this area of law. You've
Yeah.
got two separate layers of analysis. You've got it has to be a valid contract, yes, but it also has to be enforceable under the state law. And of course, every state is different. So heck, if you're a multi-state agency, that's even riskier in terms of having one boilerplate non-compete and seeking to enforce it. But the bottom line is, you have to have legitimate business interest, and it can't be broader than necessary. And so, for example, if you could say, well, you can't go to a competitor in the state of Florida for the next 2 years. Why?
Yeah.
If this person already has a non-solicit saying they can't go after the customers, okay, and they've already got an NDA saying they can't use confidential information, they can't go after referral sources, vendors, etc. What is left other than simply preventing this person from going to a competitor, period?
Yeah.
That's an anti-competitive purpose, which is not a legitimate business reason under any state law to enforce these.
Yeah. Yeah, absolutely. It's I think this conversation is a challenging one for a lot to wrap their heads around. That's why I'm excited we're going into the detail about it today, because there are so many things you can think about, and you can either think about it too much to the point where you've overanalyzed it and overimplemented something. You could never think about it to the point where you have risk, or you got to try to find that middle ground, I guess, right? Where it's like, what are we doing to protect us in a reasonable way? And also from the employee perspective, are they feeling like the agency or the business is, trying to own all the work that they've done or what they brought on board as well, right? So we got to make sure from the business side and from the employee side, it's a good mutual agreement when you start and when you leave. Obviously, amicability is high on the list for most, but it is something that we challenge. That it can be a challenge, right? Because leaving amicably, most people would say they want to leave on great terms, and either have a reference or people they can lean back on, or refer to their experiences. But that's where sometimes this becomes a challenge if there's certain contracts or non-competes or things like this in place, where it's like, well, I'm going to a competitor or a similar business. I clearly can't use this company as like a reference. I can't really use any of the information or knowledge from there and share it. So it's kind of like, what does that mean even? But yeah, it's a great point for sure. All right, so we have two more questions left, Will. And we've already kind of talked about this through some of the examples that you've shared, but just to reiterate the question for the audience, can you share any examples of successful strategies or best practices that home care providers can adopt to attract and retain top talent in a post non-compete agreement landscape?
Yeah, it's no different than a non-compete landscape.
Mm-hmm.
And frankly, this question is better suited for a HR type consultant. But
Yeah.
the bottom line is, it's the things we all know. You
Mhm.
need to have a great company culture and competitive compensation. Okay. Most of the people who leave, not just home healthcare agencies, but anywhere,
Yeah.
it's for one of two reasons, overwhelmingly. They felt they weren't getting paid enough, and not by like a de minimis amount, by usually like a competitor offered them substantially more.
Hmm.
Okay. Or they felt they were in a toxic work environment.
Yeah.
That covers the vast majority of everyone in America who leaves their job. Okay.
Absolutely. Yeah.
So if you can nail those two items, okay, where you've got a great company culture, and you are keeping happy your most important employees, the
Mhm.
ones where you would feel the pain if they left.
Yeah.
If you can do those two things, you're going to be just fine in both a non-compete landscape and a post non-compete landscape if that comes to fruition.
Yeah, absolutely. And you put it beautifully, right? And I think we've all probably experienced this and throughout our careers. I've had a 11-year career myself in technology and sales and management. And I think, I've changed jobs a few times. I've probably over the last 10, 11 years had 3, 4 different employers. And usually every time it was because for the same job somewhere else, they offered me more money. That was pretty common, right? So it's like you want to grow your career and kind of level up, if you will. There has been an instance for me personally where I did leave. I was a very well paying job, but I left because it was just a very toxic environment. And I didn't feel that that was sustainable for me or even for the other employees. The turnover was immensely high. They had some kind of, very, very, I'm talking from like the 90s style, like rules in place, and they weren't
Yep.
like adapting to the times. I think that's the biggest thing, right? You can, put contracts in place, NDAs, all those kinds of things. You can do it or not do it. I think the main thing that companies or agencies, even in our space, can do is treat the employee well, make them feel important, make sure you have pay equity so it's competitive with what other companies in the industry or in the state are paying, for that job from a reasonable perspective, right? And then the other thing is the culture. Do people wake up every day and love going to work? Are they passionate about what they do? And if the answer is no, well, we can do all the legal stuff we want. We can put all the NDAs, non-competes, or solicit agreements in place. It's not going to matter. People are going to go for what motivates them, which could be culture, could be money, could be both.
Correct.
Yeah. So I guess, from there, that's a beautiful example. And I think it's highly relevant. And as it is to home care, it is also relevant to really any other line of work. The last question I have for you today, Will, is looking ahead. What do you predict will be the most significant challenge or opportunity for home care providers as they adapt to the evolving non-compete regulations, and how can they stay ahead of the curve? I know you already kind of talked about this, but would love your input on this last and final question.
So while I hope my crystal ball is wrong, I expect there to be a uptick in the amount of disputes over non-competes over the next few years. And I think the reason for that is one, you've got an increased workforce, including in the home healthcare space, that's resistant to signing non-competes.
Yeah.
And so I think it's important for home healthcare agencies to get granular on their workforce in terms of which ones really should have non-competes. Clearly, not all of them should. Okay. And the ones who do, putting thought into the scope of that non-compete and not just being knee-jerk reaction and saying this whole state or this whole region. Okay. Um, the other element is, you've also got individuals who are not only more resistant to signing them, but also increased willingness to fight them.
Yeah.
And so you've got, things like the rise of, LinkedIn being ubiquitous,
Yep.
and other platforms where the workforce is more able to educate themselves and hear people's opinions than ever before.
Yeah.
And
Absolutely.
the opinions you're seeing on those platforms are very crystal clear.
Hmm.
People don't like non-competes,
Yeah.
okay? And they know that other people don't like non-competes. But then you combine that with this third factor of more and more private equity, okay, getting involved with the space. And what does private equity look to do? I mean, they seek to, they make their money in the margins. So I
Yeah.
think you're going to see continued, perhaps cuts in compensation or other benefits. And what does that do? That goes back to earlier. People are more likely to leave. And so I think that combination coupled with, if this is a big if the FTC ban does not become effective, which I don't think it will, if it doesn't become effective, you have a workforce that's more willing to fight back on this kind of stuff with more private equity involved. That's a recipe for more litigation.
Yeah,
And
absolutely it is.
so my recommendation truly is, and this is, and I'm someone who I'm not politically, hey, no non-competes, or anti-employer, absolutely not. The vast majority of my clients are employers.
Hmm.
They are the home health care agencies, not the workers. My recommendation to them, even behind closed doors, is let's see if you actually need any non-competes for any of the workforce.
Yeah.
If you don't, then do away with them. I spent a large portion of my career working with some of the largest home health care agencies in the nation. And your jaw would drop if you knew the amount of money they spent on legal fees each year,
Could
just
imagine. Yeah.
specifically over non-competes.
Hmm.
I mean, we're talking in the millions, many millions. And even back then, I would be thinking, if that money was instead used towards culture and compensation, and they found other ways to protect their business interest, it just makes you wonder. It makes you wonder, um, you know, were they making the right, you know, cost benefit analysis there?
Yeah.
Okay. Um, but I think it's important that, and that could be a challenging analysis to do, but I certainly encourage employers to do that analysis before going and having non-competes, and certainly before going and spending a ton of money to enforce a bunch of non-competes.
Yeah, it makes a lot of sense, right? I think that CBA, or the cost benefit analysis, I should say, it is an important one because you have to weigh the difference. Like, what am I going to spend in legalities versus can I just increase pay a bit more? Or can I just, maybe put some more employee programs in place, like some wellness programs? Some of that, a big topic I've been reviewing, and I even did a podcast about this the other day, was self-care as an employee within the home care space. And there's not a lot of businesses that value, I wouldn't say they don't value it, but they don't actually offer these kind of wellness programs for self-care as an employee in the office level at an agency or as a caregiver themselves, right? And I think if more resources were put into those things, you would see less litigation, less need for NDA because people like what they do and they feel like they're treated well. And
Yeah.
I think the other thing that you mentioned that is really, I think it's a burning platform, if you will, right now. It's a hot topic. It's social media. It's the voice people are putting out there, and they're explaining, the challenges they've faced or the experiences that they've had. So they're now being more vocal about these things, and it's making others even a bit more apprehensive about making the switch to a certain line of work, a certain industry, or working at certain companies. And I think that's a big risk, and you've probably seen this time and time again. When an employee leaves a company where they leave and they're unhappy, they're much more likely to be vocal about that on Glassdoor or other, company review sources. And people are now a bit more savvy. They're gonna, is this company good
Or,
to work for? They're gonna
or
review
God
them.
forbid, the worst case scenario, the Google review for the
The Google
customers.
review, yeah, exactly. So it's got the Google review, you got the Glassdoor. I'm sure there's like
Yep.
some million other platforms out there now in this digital age, but those are the other things that companies should be kind of considering, right? It's, what are the optics of when we hire and when people leave? We want that to be that gap to be kind of small in terms of happiness on the way in and on the way out. That's why exit interviews are immensely important. What could we have done better? How could we have kept you? And is there a chance you come back in the future? These questions that you're asking, very basic, but it gives you the insight into how you can prevent these things from the future, which again, all boils back to the same topic of, do we need an NDA? Do we need these things in place? Is it worth the fee? So in most cases, you can say yes, but I'm sure in a lot of cases, you can say probably not.
And listen, all the things you're talking about, they're not easy. It's not
Mhm.
easy to get it right on all of
No,
those things, but there's no question it's worth trying to do. And
yeah,
even putting in the effort in a visible way for employees to know that you're trying, even that itself has often a big psychological impact on the
Yeah.
workforce wanting to remain there.
Yeah, and I think you're hitting the nail on the head there, right? There's no silver bullet. There's no right answer to this, but I think what you can do is be iterative and you could learn. And I think as long as you implement the idea of continuous improvement, continuous learning, you're going to have gaps along the way. No one's perfect, and there's if there was a good strategy for this, that everyone would just download it from Google and find it on the internet and implement it, right? For free, right? But it's people pay a lot of money for consultants to help them get this thing right. And even then, it's never truly a blanket fix. But yeah, I think this has been such an insightful conversation. Will, I think we can leave it at that in terms of the questions. I want to extend my thanks to you for really sharing your expertise, and of course to the audience that's going to tune into this. Until next time, this is Mike signing off. But we do hope you found value in this very challenging conversation about the FTC and the programs, or that may or may not happen here soon. Thanks, everyone. Until next time.